that'd be fine. Well, let me go ahead and, before you call it to order, let's see if the board, I've got a request on the cell towers to reverse the order on those and put the Jennings Road first. And then I've got a request for the appeal on Apple Creek Drive to move it to the top of the agenda. I have a caregiver that has a special needs child at home.
You guys have a problem with that? No, let's do it that way then.
Okay. You can go ahead and call a meeting to order then.
Okay, it's 6 o'clock. It's time to call this meeting to order. Want to do the roll?
Stan Hedrick. Bruce Damrow.
Here.
And Larry Chesney will be here but late, and then Brian King. Here. And Mr. Walker's absent.
Okay, we all got a copy of last month's meeting minutes. Is there any additions or corrections to it? Do I hear a motion to accept them as submitted?
I'll make a motion.
Second? All in favor say aye. Aye. Opposed? Okay, we're here tonight to, then we'll go ahead right and start with the Apple Creek, correct?
That's correct.
Okay, we're going to start with the Apple Creek at 1228 stop use.
Yeah, this is an appeal to a stop use order that I issued to Sandra Scarborough for the commercial activities at 1228 Apple Creek Drive. On January 21st, 2015, I issued a stop work use that is being appealed. A complaint came into my office about commercial activity going on at the address in question. I made a visit, and there were several box trucks parked on the property, and based on the complaint, off-site workers would come in the mornings and get into those trucks and later return in the day to their automobiles. After issuing the stop use order, I have had a few conversations with the property owner and others involved with the activity, and I came to discover the following. An off-site business that has a warehouse is using this location to park their trucks because one of the business's employees lives at the residence. The employee's not the property owner. Based on my review of this situation and our zoning regulations, this activity is in violation of our zoning regulations. And the applicant is, of course, appealing that decision.
Is there anyone here to speak in favor of this appeal? Sir, please come forward.
This is speaking in favor of the appeal.
In favor. This is in favor of the appeal.
Hello, sir. My name is John Hayes.
Okay.
I live at the residence at 1228 Apple Creek Drive. I am a part owner of a courier business, and I park my trucks on the property. So I don't know what the problem, where I'm in violation.
Okay. Any other comments in favor of this appeal?
I'm within the rights of the Property Owners Association. I'm not violating anything there. I've got copies of that as well, so.
Okay. Any other pro? Do we have any? Thank you, sir. Anything else you'd like to add?
Not at this moment, but
We may have some questions later. Okay?
Yeah, I may have some questions.
Is there anyone here opposed to this appeal? Please step forward.
I'm Brian Garner. I live across the street from this, and
What's your name again, sir?
Brian, B-R-Y-A-N, Garner, G-A-R-N-E-R. I've lived at this residence for more than 26 years. I bought it from John Loop after he built it for his daughter, and he moved away. And I'm one of the still standing people that's been in that subdivision. The subdivision's only been there like 27 years, and I've been there right after he built it. I've never known a business to be run out of our subdivision. And I've got pictures here to show you, and I have a special needs child. They run in and out all times of night.
Would you like to bring them up here?
So here lately, they turn the lights out now. They start the trucks up at 3 and 4 in the morning and run them to warm up, and then the lights are on in his bedroom. He has seizures, and I've told this gentleman about it, but he wanted to come explain. I just don't see the like of it to be in a subdivision. It looks ungodly over all the time, and after they served one, come by and told them about it, they still put a driveway in of gravel to park those trucks. And it just looks a mess over there, and I have to live across the street, and then pretty soon we have remodeled a house down in the country to move to, but it would be hard to try to sell a house right across the street from that, you know.
Okay. Thank you for the pictures.
Yeah,
Do you want to submit those for the record?
I can.
Thank you.
And I also have notes typed up if you'd like to see them. So,
Sure, please. Thank you. Would you like to submit those also for the record?
yes,
All right. Yeah, we can do that. All right. Anything else you'd like to add to your opposition?
no, they also have a pit bulldog that they do keep in the house now. I complained about it too, and service people come out and warned, gave them notice on it that if they didn't keep it put up, but they keep it in the house now. But it almost attacked my wife there, and then it ran me in the house. So I mean, they keep it on a chain even when they walk it. So
Okay.
that I don't think that's in the note. but I
No, that's not,
wanted to state that too.
that's something else. That's a different issue. Thank
Yeah.
you, sir. Thank you. Understand.
But all this, you know, the special needs son, we walk him in that subdivision, and that dog attacks. I mean, he could very well, I mean, he, you know, attack anybody, you know, that's part of it.
Okay.
So I just wanted to state that too.
All right, thank you.
All right. Sit down.
Yes, sir. Yes. Any discussion on the board? Sir, how long have trucks been parked there? For individuals asking for the appeal.
How long are they parked there?
How long have they been being parked?
I started parking it there about 2 years ago, and we kind of grew a little bit. And actually, those pictures are outdated. I've cleaned it up. It was winter time, and we had added a couple trucks, and we didn't want to park them on the streets. So, you know, and I spoke with Mr. King, and he voiced his disapproval of it, and I did the best I could to appease him. So.
I was up there yesterday, trucks were there.
I actually have a picture of updated on my phone. I didn't get a chance to print it off. So
Yeah, there was like 4 trucks in the yard yesterday.
Is there a covenant in your subdivision?
What?
Do you have any restrictions in your subdivision? Do you have bylaws of your subdivision? He does. Okay. Would you like to enter those into?
sure. If you look on number 10 there and number 13, that's just the front page right there. It's not all of it.
May I show you a picture? This is what it looked like yesterday. Is that typical?
Right, yeah, we've got it cleaned up and,
That's clean?
well, I mean, the trucks were in the lawn before. We put a gravel pad in there so we don't mess up the grass anymore.
All this come about place after we found out we had complaints coming about it, though. For 2 years, and it's just been cleaned up in the last little while.
Yeah, just a moment, please.
I'm sorry, have they disclosed the type of business that's being run there?
No, we haven't got to that yet.
Keep in mind, we're just enforcing zoning regulations, and my interpretation of our regulations are what's being appealed.
Those are the restrictions within the subdivision, or part of them anyhow. Any other discussion? Sir, would you like to add anything else? Would you like to add anything else?
No, I just, I never know the subdivision to have, transportation in it. I'm sure you live in a subdivision, or anybody else in here, you all don't have a trucking transportation out in the subdivision. And this is just across the street from Mimosa Estate is where this is, and it's down at Apple Creek, just some subdivision, little houses in there, I think about 18 or 19 houses.
Okay.
And, I just never know, and like I say, I told them we had this special needs job about like that, but I mean, even if it was just me myself, I wouldn't expect a trucking company to be run out of subdivision.
Okay. Okay. Thank you.
Can I add one more thing?
Yes.
There's actually the gentleman adjacent to him. He actually, he's got trucks and trailers that go in and out all day as well. And he actually parks his on the street. I keep my stuff on the property, and try to keep it going. It's just where we park. We're not running anything out of there. We're not taking deliveries in there. Where I see he is, we're just parking the vehicles there, and I know it's actually, it can be a little unsightly, but I mean, I've got to earn a living, so.
Okay. All right. Thank you.
Where's
More
your,
questions?
where's your office?
Where's the office?
Yeah.
My partner actually has his office has our office at his house. The company Smoky View Coastal is incorporated for 251 Lee Shirley Road, and that's in Greenback.
Does he not have room to park them?
He doesn't have room to park, and it's off the beaten path, so it makes more sense to have them where I have them.
Any other discussion, gentlemen? Do I hear a motion?
Okay. The motion would be to deny him having approval to park his trucks there.
Yeah. It's either yes or no.
He's appealing his request is to appeal my decision that is in violation of our zoning regulations based on they're in the suburbanizing zone. And there are uses that you can do at your home, and they're called customary home occupations, but that's like having a barber shop or a real estate office or something like that. So it's pretty non-impacted to the area. This doesn't fit into that description, and it doesn't fit into the description for a family commercial enterprise that you could get approved as a special exception. And so therefore, under section 9.1 D, uses that are prohibited, all uses are prohibited except those uses permitted specifically by the Board of Zoning Appeals. So,
But all we're dealing with is the stop work issue.
correct.
That's
So
right.
if you vote to approve his appeal, it would be saying that he would be allowed to continue the activity. If you made a motion to deny the appeal, it would mean that the stop work order holds.
I would make a motion to uphold Roger's stop work order.
Second.
I have a motion, I have a second. All in favor say aye.
Aye.
Opposed? Motion carried. The
Now, we voted to
appeal, deny the appeal. That could get confusing. All right, the next issue is we're supposed to take up, did you say, Roger, the one at the,
Well, we were going to reverse that one. If we can hear the one on Jennings Road, but the next item on the agenda was the variance requests,
okay,
but we just swapped the antenna.
well, why don't we go back to the variance request, so we do the one at 231 Miller
West
Cove?
Millers Cove Road.
One at Miller Cove Road.
This request is for a variance from front setback requirements. The property is identified on tax map 83, parcel 11.02, and is zoned R1. The required setback is 60 feet from the property line running along Highway 321. The requested setback is 30 feet to match up with the existing storage buildings that are located on the property. These buildings predated our zoning regulations. This property is on quite a bit higher elevation than the highway. The proposed site is the only location that has a favorable grade for the additional buildings.
Is there anyone here in favor of this variance? Would you please step forward?
I'm Stan Hedrick, and my wife and I own Parkway Mini Storage on this location. We built them in '99, predating zoning, and we're going to build them out in 2007 before the recession hit. It hit, but now we're full again, and I have a backlog. This piece of real estate is bordered on three sides by 2 county roads, a state road, and then the park. When we built these buildings, I think at that time the setback was 30 feet. And so we put the first 150-foot building 30 feet from the line, and it's enclosed with a chain link fence. So this building that we're wanting to do now is to finish it out. And on the 20-foot section, we want to keep it in line with the 150-foot building, and it just be symmetrical on everything.
Thank you. Anybody else here in favor of this variance? Anyone here opposed to the variance on 231 Miller Cove Road? Discussion, gentlemen?
Will the new building, is that the one marked in black on what you sent us?
It's got the, I would assume it's got the circle, not the circle.
Yes, it's
but
the one I just kind
rectangle
of drew it
around.
in there on that aerial photo just to give you an idea of what they were requesting.
Will the new building be any closer to 321 than the existing building? Same.
Any other discussion from the board? Do I hear a motion?
Motion to approve.
Second.
All in favor say aye. Aye. All opposed, nay. Motion
I'd like
carried.
to get Stan abstained.
Yeah, I would figure that.
I just want to get that
Oh,
on the
okay.
record.
Okay, next item is exemption, right, Roger? At 3812 Big Springs?
It's another variance. Yeah, we're done
Yeah,
with that
you
one.
can go.
Yeah.
The stop work appeal was denied. He has to stop work, yes. He has to stop work, yes. No problem, thank you,
Just
Bob.
let us clarify this, gentlemen. How long does he have to stop putting parking his trucks there? Is it a year, or a week?
Well, he'll have to,
He'll have to move it,
he'll have to move them, yeah.
Does
I'll
he
get
have
him a
day,
letter.
A week or a month?
whatever the
There's
stop
no
work.
written, but I'll get him a letter tomorrow.
So he can expect him to have it gone in a week or so?
Yes.
Yeah.
Okay.
Oh. Is there anyone here that would like to speak in favor of the exemption at 3812 Big Springs? Nope, we did that one.
We got one more variance on there.
Okay, we got one more variance. That would be the one at 409 Old Niles Ferry Road.
Yes, this request is for front setback requirements. The property is identified on 90J Group A, Parcel 5, and is zoned R1. The required setback's 30 feet from the property line running along Lett Drive, and the variance is being requested for a detached garage. The requested setback is 31 feet from the curb, which is where they actually measured from instead of the property line. And the hardship is the area reserved for the septic is basically everything behind the house. And I think I included a picture of the plat that shows that area being hatched and unusable, and then actually the septic system is laid out directly by the house now. So to avoid that, and it is impacted by 2 front setbacks, the one, other than the one in question, also a 30-foot setback from Old Niles Ferry Road.
And that's, yeah, you have that sketched in on the picture, or the photo, I should say.
Correct.
Okay. Is there anyone here that would like to speak in favor of granting this variance? Anyone here would like to speak in, okay, thank you.
I'm Justin Richmond. I'm the contractor on that project. The issue is actually the side, not the front. What we were kind of going off of was what the permit stated for a side setback of 10 feet. Like was stated, I think we're 31 feet off the curb, which appears to be the property line on the plat.
Question?
Yes,
Yeah, he has, wait, sir, he's got a question.
if you're 31 feet from the curb, why, what's the problem?
The required front setback, and a front setback is defined by any property line that runs along the public road right-of-way or road easement line. So that establishes the front setback, not the direction the house is pointing. So this property actually has 2 fronts and 2 sides. And you don't measure a setback from a curb, you measure it from the property line.
So the property line is toward the house from the curb.
Correct.
So how many feet is he out of compliance?
I don't know exactly. Based on 31 feet, it would be a guess, but I would guess probably 5 or 6 feet.
Where you have the corners laid out, is that where you're gonna put the garage?
Have you had it surveyed?
No.
Is, on our little map here, the white line that comes around the side, is that right about the property line?
Is this easier to see, Stan? It's in color?
No, I looked at that
You
too.
talking about the red line?
Yes.
Well,
The red line?
it has this little map
Yeah.
line of,
Yeah.
that, is that about the property line? And then we got the curb 31 feet, so if that's right, you may be 20 feet, 22 feet.
Something like that.
I mean, he's like 25 feet off the curb, off the curb.
Yeah.
He's 31 feet off the
It
curb.
says 31 feet.
Yeah, but if the property line's 5 feet, he's still 25 feet from the property line.
Right. Thank you. Is there anyone opposed to this variance? Any more discussion?
I would like to add that I did have a few neighbors call about when the sign went up, and once they found out what it was, they had no opposition.
Okay, thanks, Roger. Do I hear a motion?
Motion approved.
Do I hear a second?
Second.
I have a motion to approve and a motion to second. The vote will be for granting the variance, correct, Roger?
Correct.
Let's take a vote.
Bruce Stamro,
Yes?
Larry Chesney,
Yes.
Stan Hedrick,
Yes.
Brian King.
Yes.
Variance was approved. All right. Now we can move on to special exemptions,
Yes.
right? All right. And
Go ahead.
No, go ahead. Miller's Cove, right?
This one's
Big Springs.
Big Springs Ridge Road, 318, and this is the one where they're wanting to do, I guess you'd call it a partial change of use. You deferred it from last month, wanting to know if there was any other regulating body that would handle pet crematoriums. Just on a web search, I couldn't find anything.
I couldn't either.
I don't know if the applicant's in the audience tonight, if they've found anything.
Did you find anything else out?
I made a lot of phone calls. I talked to a guy over in Knoxville. His name is Jarrett Rudd, and he's an environmentalist specialist in the Air Pollution Control Division. And he said to his knowledge, the state didn't have any regulations of bodily fluid or anything like that. But he made a lot of recommendations, and he said that we need to put a procedure together in case something does spill out or happen. But, we talked in length. I've called him several times. He's been a big help. And he was saying that, the vets tag everything and bag everything, and everything is pretty well sealed and removed out of freezer compartments. So, anything can happen, but, it's... we would just have to have a procedure to follow and, have a chemical like they use in hospitals and stuff, detergent and stuff that would dilute and, and clean up. I live there, so, I want to keep it clean and, in order and everything, so.
Okay. Is there anyone like to speak against it, opposed? Discussion, gentlemen?
You put bagnall in the incinerator?
Yes, it's environmentally compatible, and this guy that I talked to, he's the guy that I've got to go through for the air pollution control permits and everything. If this gets passed here, this is just only the beginning. There's just a ton of paperwork to. After I'm by the incinerator, I have to wait 101 days for a construction permit and everything. So there's just a lot of paperwork involved. So, but this is just the first step.
Make sure I understand the process. The vet puts the animal in the bag,
Yes,
puts it in the freezer.
yes,
Then you put it in your freezer.
yes.
And then when you get enough animals to process, you
I-
take all those and put it in the incinerator frozen.
Yes, I'm planning on offering a service since I'm starting out, and that's one thing, there's so many local vets. I'm hoping to pick them up and go ahead and burn them and get them back to the people. I talked to Countryside, and they have to have at least 3 in their freezer before the people in Seymour pick it up. So, I'm gonna try to stay a local thing and, stay small and offer a service, so. But yeah, that's how it's handled, so.
You give the owners back their ashes,
Yes, yes.
so you keep that separated in the incinerator.
Yes, the incinerator I'm gonna get is a 500-pound one, and you can do single burns or multi-burns, but they make a stainless steel tray that say that the small animals go in, so you can put 3 or 4 in there, and they're closed in a stainless steel tray, that way the ashes don't mix or anything like that, so. And that's a big concern with owners I've talked to, is they wanna know that they get their pet back, so.
Any other discussions? Do I hear a motion?
Move its approval.
I have a motion to move to approve. Do I have a second?
Second.
We have a second. Ready for a vote?
Who got the second? Brian? Okay. Bruce Damrow?
Yes?
Larry Chesney? Stan Hedrick?
Yes.
Brian King?
Yes.
Approved.
Approved.
All right, thank you very much.
All right. Now unless my list.
Now, this is where we switched out.
Okay, that,
Yeah.
so now we're gonna do, which one did you wanna do first?
Jennings Road.
Okay, we're gonna do the exemption, correct? At 750 Jennings Road?
Yes, this is, just to bring you up to speed, this one was deferred from last month also. It was for the 150-foot cell tower. They relocated on the property to be able to meet all the separations requirements. There was questions concerning the road. I've talked with Mary a couple times, and after talking to the county attorney, trying to avoid the county being a third-party administrator of a bond that's put on private property, and came up with a suggestion that maybe you approve the tower without the antenna, and then once the road conditions confirmed to be as it was prior to the construction, then turn loose of a permit for the antenna. That was a suggestion. Of course, I know that Mary's been working very hard on other things too.
Is there anyone here that would like to
Okay.
add more information?
Again, I'm Mary Miller. I'm here on behalf of Branch Towers and T-Mobile, and we're requesting approval of the 150-foot tower. If you don't mind, I'd like to do a little house cleaning. Generally, I like to submit a package that provides our evidence that we've submitted to y'all for approval of the tower.
Okay.
It's the things we've submitted with our applications.
Okay.
And we'd request that those be entered into the record. As Roger said, I think we've meet all the requirements of the ordinance. The big issue last time was the road. The first part of that is there was a question about whether the Carringtons, our landlords, had the right to grant us the use of the road. We believe they do. We've brought in an expert witness, Mr. Greg Shanks. His resume is contained in that packet. He has 30 plus, almost 40 years, he probably wouldn't want me to tell that, experience in real estate law. He's a very well experienced title attorney, writes title for all the major banks, real estate people, has significant experience in the real estate area. He is prepared to give an opinion today that the Carringtons do have the right to grant T-Mobile and Branch Towers the right to use the road. In addition, he's prepared to testify that the usage wouldn't unduly burden the easement. And if you'd like to put on his testimony, we would. The second part of it is we, pursuant to your request, we met with the homeowners on April 23rd. We had a meeting at the Blount County Library. We probably had, 15 to 20 people show. We had 15 to 20 people show. There were, I will be frank, there were some people who still just don't want the tower, and there were some people who came to try to work out an agreement about the road. After that meeting again, I met with Julie Watson and Karen Branch. The Branches live right beside the Carringtons, beside the tower site. The Watsons live across the road. We again met, discussed, worked out an agreement about how to handle the issues on the road. Branch has agreed to, because we can't do a bond with the county, and because they don't have a homeowners association, What we've done is said, okay, we'll reach an agreement with at least the Branches, the Carringtons, and the Watsons, and anyone else on Jennings who will enter the agreement. The agreement will be that we will put in $15,000 for the maintenance of the road. That's ongoing maintenance. We'll have a written document. Branch has agreed to pay for the attorney. Miss Watson and Miss Branch elected to talk to Dennis Ragsdale, who's a very good real estate attorney in Knoxville, probably one of the best, and they've already met with him about it. And we've talked to him about it, come up with a concept. It's kind of like a quasi-easement road maintenance agreement. Okay, so we'll put the $15,000 in. They will use it to maintain the paved part of Jennings Road that comes from Middle Settlements and then curves around. It will go to the edge of the Carringtons' property, come across the front of the Carringtons' property, won't go past the Carringtons' property, and will not go down Echo Hill. Okay, but it will. This is what the tower company will be using. In addition to that, Branch has agreed to post either a bond or a letter of credit. The beneficiary of that would be Miss Watson and Miss Branch as agents for that group. Okay, for those homeowners. It'd be like a construction bond or a letter of credit on a construction project. And we would post that in the amount of $65,000 each when we construct the tower, when we remove the tower, and each time we set a set of antennas. So when we came in to get a building permit to build the tower, to put on antennas, to take down the tower, we would post a bond. We would show, or not post it, but we'd show evidence that we've got this bond issued for their benefit. Be in the amount of $65,000. The bond will go from 1 year after the issuance of the building permit. Generally takes the tower companies, they go real quick. Ours is kind of like the Japanese. It takes us a long time to get to construction, but once we get to construction, it's pretty quick. Generally takes less than a month. The erection of the tower generally takes 1 to 3 days once we've got the pad and everything poured. So we felt like a year from the issuance of the building permit would be enough time to determine whether there's problems with the road. There would be a mutually agreed upon person who would inspect, not anybody with the county, unless they wanted to do it privately, but would be a mutually agreed upon person who would inspect the road prior to construction and after construction. If there's a problem, the homeowners would then make a claim upon the bond or the letter of credit. Okay. I feel like we've made big efforts to try to address the road issue, even though we have the rights. The other thing I would point out to the board is just about all of the deeds, I think, except one, provide that each landowner shares in the pro rata costs of the maintenance of that road. So our landlord would still be responsible for his pro rata share of the maintenance of that road as well. I guess, are there any other questions? Yeah.
The first was 11,000 or 15,000?
15,000.
Does Miss Watson and Miss Branch, can they spend that 15,000 on the road when you get through construction at their discretion?
Yes.
And it doesn't matter what you think about what they're going to do with it.
No. And honestly, we don't want to be.
Those two ladies then can decide how to spend that 15,000 unilaterally.
Right. And they're here to speak to it as well. I think that they're I have met with them and become great email and text friends with them over the last month. And I do think they're very responsible and and part of the reason they came is because they want to see the road maintained. And so they are here, and that's why we asked. Ms. Watson works and has to get up early in the mornings, and that's why we asked to move up. And so they're here to speak to.
Okay. Anyone else speaking in favor?
And the only thing is, could we put on Mr. Shanks' evidence
Sure.
just real quick, very
Sure.
shortly? This is Gregory Shanks. And could you tell them who you are and
I'm Greg Shanks, I'm an attorney from Knoxville. Been doing this a long time.
about, what, 30?
36 years.
Okay.
Except for 4 or 5 years with the government.
And your
Would you
concentrations
go
in
up
real
to the-
estate?
Sir, would you go up to the microphone so everybody can hear in the back? There's a microphone right there.
I'm
Would you
sorry.
please address that?
Yeah, I'm sorry, thank you. What I looked at was the quality of the easement as it goes to these properties, and we use the term quality, but the easement that goes to this property and to virtually all of those properties is what they call a non-exclusive easement, that not only do the Jennings who created these easements reserve the right to grant it to a bunch of other people, the recipients of the easement, they declare that they understand that other people are going to use it. So when the easements were granted, not only to the Carringtons, but everybody up that road, everybody had, with the exception of 1 or 2, had exactly the same language. And it was interesting that the easement said in it that they called it a right-of-way, which for the most part, everybody uses those interchangeably. There's really some difference, but everybody for the most part uses them the same way. They said that the right-of-way hereby conveyed is not an exclusive right-of-way, and that each of the parties hereto, which means the people that got it and the Jennings that kept it, so that when they gave it to other people, may use said right-of-way and may also grant the right-of-way to others to use said right-of-way for the purpose of ingress and egress. Now, it's interesting to notice that it says that the people that get this right-of-way may grant the right to use it. And that's different than conveying it off to somebody else, so that, for instance, if I've got my piece of property and I split it in half and I convey the property in the back, I can convey that right-of-way to that piece, and instead of having one, now I've got 2 people using that right-of-way, which is a little bit different issue. It says that I can grant the right to use it. So if I lease this back property, like for a cell tower, for instance, that I've got the right to grant somebody else the right to use that. So all of these properties in question, virtually all in question, have that same language. They have the right, that it's non-exclusive, that they have the right to grant other people the right to use this easement. And then the easement specifically says that the above right-of-way is assignable. So it was contemplated by the Jennings when they created these easements, and all those people, which is where the Jennings Road came from, that it was going to be freely assignable, it was going to be transferable, and that people were going to be able to loan out the easement, transfer it, and sort of split things up. Now, where we get into trouble, and I'll be brief, this is a little primer on easements. Where you get into trouble with easements is there's 2 issues that come up with an easement. One is when people try to enlarge, an easement is when I give you the right to come across my property to do something with, and in this case, it's ingress and egress. And where we get into a problem is when I give you the right to go across my property to get back and forth to yours. Sometimes the people that have the easement, which is called the dominant estate, when those people will try to, number one, enlarge the use so that you've got the right to cross my property to get to yours, and you decide that the guy that lives behind you is a nice guy, and it'd be a whole lot easier if he could run down this easement to get to the front road. And so you say, okay, fine, you can use my easement. Well, that's enlarging the easement, which it was never contemplated that, I gave you the easement so you could come down through here. I didn't give you the easement so the guy behind you could do it, and that's enlarging an easement, and that is a rule is not allowed. The other issue that comes up is when you increase the burden on the easement, and that's a little bit different issue. And that's when I gave you the right to get back and forth from your property down to the Middle Settlements Road, for residential purposes or whatever was contemplated at the time, and you got 1 house, 2 houses, a house and a horse barn, a house and a 20-horse barn, and you decide that you're going to put a Foothills Mall in on your property. That's when you that's when you get into the issue of the burden on the easement, and you go from now, you've got a house that has 10 cars a day going in, to now you're wanting to put in a strip center that now has 300 or 400 cars a day coming in, and that's where you get into overburdening the easement. Now the question, the problem is not whether you overburden an easement. The question is whether you materially overburden an easement. So, you know, a typical house has, I guess the rule of thumb is 10 cars a day. I guess that was the old rule. I don't know what it is now. But let's say I give you the easement to get back and forth to your house. The rule of thumb is 10 cars a day. You put a mother-in-law apartment in, or you put another house on your property, so you go from 10 cars a day to 20 cars a day. Does that materially overburden the easement? It may overburden the easement some, but the issue is, does it materially overburden the easement? And that's the question, material overburden. And there's a good case, a nice, simple, clean case, which is so rare in our business. But it's a good, clean case, and it just summarizes all this stuff. And they talk about that the issue is whether that you cannot materially increase the burden. But it also goes on to say that it's established where the additional burden is relatively trifling, the user will not be enjoined from using the easement. So there's the issue, is materially overburden the easement, but that if it's relatively trifling. So in our case, for instance, you've got a house where you have 10 cars a day going in and out, which is roughly 3,600 trips a year going in and out, and you're going to put a cell tower back there where once it's built, a truck's going to go in once a month. There's another 12. You're going from 3,600 trips a year up and down this easement to 3,612 trips a year, and that's not, in my mind, materially overburdening, and that is trifling, increasing the burden. So that, in a nutshell, is what we're talking about. Is it a material overburdening of the easement? And I'd say that it wasn't, because that's the issue, whether it's a material increase in the burden.
What about bringing the crane to set that?
Bringing the crane in doesn't change the tone, doesn't change what the easement is. The easement's for ingress and egress. And it would be the same thing as if you're building one of these great big fancy log homes like they do up in Gatlinburg, where they bring in these giant cranes to set the logs and set the, set the joists and rafters. A crane's a crane, construction equipment's construction equipment. You may bring in some giant track hoe to build the drain field or build the footers or put in a giant basement. Whether you're bringing a crane in to set a cell tower for 3 or 4 days, or you're bringing one in to build a basement, which might take 2 or 3 weeks, the easement is there to get in and out of the property. What you're bringing across it really doesn't matter. It's the fact that you're using it to get to and from this property. So it doesn't matter what you're driving across it. Okay. Now, if you're using it for recreation, like running, there's another case on it, like running 4-wheelers up and down it, and you're charging people to go roaring back and forth across it, that's different.
Okay. All right, thank you. Anyone else speak in favor of this?
Would you like the?
Yeah, if anybody else would like, now this is the plus side, okay, that you want to address us about the positive aspect of this? In favor of it?
Okay. Hi, I'm Julie Watson. I think everything's okay. Everything's okay. I really don't know what to say.
Well, are the terms of what I told the board pretty much what we've all agreed to?
Okay.
Yes. Yes, Mary and I was just kind of confused about this gentleman. I'm so sorry. Yeah, what Mary and I and Karen discussed is fine.
Okay. All right.
Yeah.
Thank you.
So
Okay.
Julie,
Yes.
You're understanding that when the tower's finished, you have $15,000 to spend through discretion on the building.
Yes, Karen and I, yes, and I mean, we're not gonna run off. I know Mark, the other guy who was here last time, said, you gotta trust the people that they're not gonna run off with your money to the Bahamas or something. That's not what we're gonna do with it. We just want the road took care of. We're just gonna put the gravel on it where it needs to be gravelled, and we're gonna patch the potholes that need to be patched up. That's what we're gonna do with it. We're just gonna take care of it and maintain it.
When you face that house,
Yes.
in the back, there's several roads. Is that a part of that property, or is that somebody else?
No, that's somebody else's property. Yeah. Not where you talking about where the tower is? Yeah.
Right, if you face that house over to the
Yeah.
right, you look down to the right of the house.
Yeah,
there's
that's
several boats back in
right. That's somebody else's property. Yeah, doesn't have to do with that property. Yes. So we're okay.
Thank you, thank
what
you.
we agreed. Uh-huh.
Anyone here in opposition of granting this exemption? Please step forward. Sir or ma'am, why don't you come up first?
My name is Shannon Green. After listening to the presentation of Branch Communications, I'm not sure now what's going on exactly. I feel like maybe I've arrived a little late to this party. I don't know, are we here tonight to discuss the actual granting of a tower, or are we past that point to where we're speaking about easements and road maintenance and it's already going to happen?
No, we're here to discuss whether the easement is, or not easement, but the exemption is to be.
Right, it's still a special exception request. Of the easement and the access to the property was a big point of contention last month, at last month's meeting. So they deferred that request and kind of gave them the board gave them some marching orders as far as trying to work out an agreement on the condition of the road.
Shannon, were you here last week?
No, I was not.
The issue was, we had an issue 2 or 3 years ago in Townsend where a cell tower went over a private road, and this issue went on and on forever, and you couldn't figure out who made the pothole. So our board said, until this group comes to some agreement, we're not going to approve cell tower across a private road until there's some agreement, because we're not getting into that conflict.
Right.
And, because you can't tell who made the pothole. So our request was, those two parties get together and come up with some agreement of how we're going to maintain the road. And that's what they presented tonight.
I understand that.
But
I think it's good to be
we are here
proactive.
to either grant or deny the special exemption, correct?
Right, but the reason we
Yeah, that's the question at hand.
experience we had 2 or 3 years ago.
Right, okay.
Well, then would tonight be untimely to voice an opinion about the tower itself?
No.
The
that's
installation of the
fine.
tower? Okay, that's why I'm here.
Okay,
To voice an objection to the installation of the tower. Now, I do not live on Jennings Road, but I live apparently within 1,000 feet of the proposed cell tower. Now, I don't know if that means I live within 1,000 feet of where the actual tower will be installed, or if I live within 1,000 feet of the property that the tower will be placed upon. But I do believe that either way, it's going to have a negative impact on myself, other members of my subdivision. We live in a rather small subdivision in a rural part of the county. And, you know, our property values are barely hanging on as it is. I talked to, not related to this issue, I talked to the tax appraiser's office today, and they told me that 76% of the residents in our county, their property values have either stayed the same or dropped slightly. You know, so we're just barely hanging on. And I think that the installation of the cell tower is going to have a negative impact on everybody who lives around Jennings Road, except for the property owners who I assume will benefit financially. I would like to have maybe some more information about it, particularly some stats on what cell tower installations do to subdivisions or housing. I would really like to see a detailed map of where the tower will be installed. Maybe some research on health issues, because we do have children in the subdivision, and some specific details of the tower itself. Should I stop talking?
excuse me. Folks, could we please entertain her conversation? Thank you.
Some details of the tower itself, the height, I don't know a lot about cell towers, so I would say maybe the height. Are there going to be, you know, array of wires or tower connecting to other towers. I feel like I don't have enough information, so I'm here to object to it, but I'm open to more information. The only thing I have received is a 4-sentence letter, and I would appreciate more information. I know that has nothing to do with you. I know that's probably branch communications, but I really am here just to voice my objection.
Okay, thank you. Anyone else in opposition? Yes, sir, please, report.
This is the Jennings Road Tower.
My name is Sam Horton. I think you saw me here last April the 2nd when I made a presentation to you voicing my displeasure with the consideration for the erection of the cell tower. Basically, what I did was made the presentation. I also presented you a listing of 126. Sam Horton, H-O-R-T-O-N.
This is not about yours, right? He's on the wrong one.
You're on the, yeah, this is not the right one.
Is this not Big Springs Road?
No, sir.
I'm sorry.
No, that's okay. This is the one, this is not on Big Springs Road. Okay. Anyone else in opposition? Yes, sir.
My name's Fred McCarg. I'm on 750 Echo Hill Way. I believe that Mary has got a good start here. We were left out. Most of us residents of this were left out of this discussion on what was going on, but hearing what they did, it's a good start. I have a question about they're going to can put 3 additional antennas on this tower, and their bond for $65,000 is just for 1 year after the start of construction. Well, 2 years from now, if they bring another crane in to put additional towers in, are they going to get an additional bond on this? Like I said, I was left out completely on all these discussions here, but the rest of the residents need to be informed of what's going on and at least have a copy of this agreement before we go on. Let's just postpone this for another month until all parties are in agreement. Thank you.
Thank you. Anyone else in opposition? Discussion board?
Would you try, Mary? Yes. Ms. Miller?
Sorry.
Would you, we understand the 15,000. Would you clarify for everybody about the 65,000?
Yeah. The bond will be posted each time we put on a set of antennas. Or it may be a bond, it may be a letter of credit. It's going to depend on which we can obtain to do for a private entity, okay? It will be posted when we put on the tower, each time we put on a set of antennas, and if we remove the tower, okay? So, for example, we go in, we put up the tower, we're going to put a $65,000 bond. It'll last from a year from the time we get that building permit. 2 years from now, we come in, we put another set of we're going to put another set of antennas on the tower. Okay, we will put up when we come in to Roger to get the building permit, we will put up another bond because the first bond will have expired. We will put up another bond or letter of credit for that installation. It'll be in the amount of $65,000. It'll last a year from the issuance of that building permit. Okay, does that help a little bit? Okay.
Can we get a copy of this agreement?
We're happy, the agreement will be recorded, and we're happy to provide it. It has not been drafted yet because we were waiting to see whether the Planning Commission the BZA would agree.
So you will do this thing?
Yes, yes. Okay.
Mary, can Ms. Watson and Ms. Branch spend that $65,000?
No, because it's what would happen in that situation is it's a letter of credit or a bond. Okay, so if there's a problem, then what happens is they go to the bank. Well, I guess eventually they could. They go to the bank and say, listen, this is not fixed. It needs to be fixed. It's going to cost us $15,000. You need to give us, bonding company or bank, you need to give us $15,000 on this letter of credit or this bond to pay to fix the road.
So let's assume Ms. Watson and Ms. Branch go in and say they need $5,000.
Mm-hmm.
Who says yes or no?
Well, we're gonna have a mutually agreed upon inspector before and after. And then if there's, at that point, there's disagreement, we'll provide that it goes to Chancery Court. We'll not be coming back to y'all.
So in a nutshell, you're gonna give them $15,000 up front and post $65,000 each time you put.
Yes. One thing I would like to address in regards to Ms. Green's, I'm not sure where she lives. I don't know. Do you live on Bollinger?
No, ma'am, I live on Love Crest. I don't know what direction that is. I'm in between Little Settlements and Jennings Road.
Oh, you're in that subdivision. Okay. The tower is going to be behind the house across Jennings Road, okay? And I have placed pictures in there which show where the tower's gonna be. It's very buffered. Particularly against Bollinger, but on all sides, if you'll see in the packet that I provided, and I'm happy to provide more to pass if you like, there is a lot of heavy tree buffering. And so in that relation, when we're looking for sites, it's a good site because there's a lot of foliage on, and it's tall hardwoods on 3 sides. Well, actually, probably at the end of the day, 4. For your information, it will be a 150-foot tower. And I don't know if there are any other questions. You know, we can't address health issues. The federal law prevents us from addressing that.
Okay. All right, thank you. Further discussion, board?
Thanks, you have a question.
Yes, ma'am.
I was going to address bridge communications. Do you have a map, a more detailed map that you could share with some of the homeowners?
Oh, yes, we've had it available, and we would have been, I'm sorry that we didn't realize you had questions because we've been meeting with people, and all that information's been in Mr. Fields' office. I'll be happy to meet with you after this meeting and show you where it is and in relation to your neighborhood on there. Okay. Thank you.
Thank you. Further discussion from the board? Do I hear a motion?
One clarification, they meet all the requirements of setback.
Yes. Their initial application did not, but they relocated the tower, and they do meet the separation requirements.
Motion approved.
Motion to approve. Do I hear a second?
Second.
Second. Ready for a vote? All in favor say aye. Oh, yeah, that's right. We'll do the roll call.
Bruce Denbrough?
Yes.
Larry Chesney?
Yes.
Ken Hendrick?
Yes.
Brian Keith?
Yes.
Okay.
I'd like to make a comment. I think the work they did on this road thing, that's pretty good. We've never had that type of effort done before.
But that's exactly what we asked for.
Yes.
What you guys came up with is exactly what should happen 4 years ago in town, with some agreement up front. Because when the pothole, you don't know whether the pothole is causing somebody putting in a new foundation of a house or the cell phone tower truck. So you did exactly what we asked you to do. Thank you very much.
The other comment too, gentlemen, and for folks out there, communication is a wonderful thing. When you sit on the appeals board, a lot of times people don't communicate to one another, and that's why we have problems. So thank you very much for what you've all done. Okay, we're ready for the next issue. That would be the one we carried over from last month at 2237 Big Springs Road. Correct, Roger?
That is correct, and I'd like to update, Ms. Miller also got us some additional information on this for the record. There are arguments for the location of the tower on Big Springs Road, a engineered letter about the tower's failure would be to fall within a 66-foot area, and I'll pass these down to you. And there's an affidavit from Brian Sullivan stating that they did due diligence to look for other tall structures and co-location sites in the area. And I'd like to clarify one thing in Ms. Miller's arguments. She makes an argument that a variance could be granted based on variances in our section 11 point, well, hold on, I've got it folded down so I can get to it quick.
I have a question on what you just said.
Yes,
Okay.
Is this tower gonna be 150 feet tall?
yes.
How's it gonna fall in a 66 feet radius?
Well, the engineer explains it there in that letter.
I can answer that. And Mr. Harris can probably answer too. And actually, they say it'll fall in a smaller radius. They say that it'll fall with like in a 20-foot radius, because what happens is they fall within themselves. They have very few instances of them falling. Kramer she's from Oklahoma, and they, as you know, have had a huge series of tornadoes this year, and they don't have any falling. But apparently when they fall within themselves. But it's just they just are very few instances. Too bad we don't build some others. It doesn't fall down a straight line. Mr. Perry can address this, but what it does is it has he's an engineer, so he can probably better describe it than I can. But it falls within itself.
My name's Larry Perry. I live at 11464 Saga Lane over in Knoxville, and I'm a consultant to this Board of Zoning Appeals. A tower, like we're talking about here, a monopole tower, at 150 feet is made to break at about 60 feet. And I put up over 3,200 towers like this all over the world. I have never yet seen one fall like that, never. They're not built that way. They're built to break in the center and come down just like that. So typically, whenever you have a monopole tower, or even as far as that goes, any self-supporting tower, they're made to break about 2/3 of the way up and come down and fall within an area of about, like I say, about 2/3 the height of the tower. So I've never seen one fall down, including the hurricanes, and even down in Katrina in New Orleans, we put up 12 of them, and not one of them came down in Katrina with 150-mile-an-hour wind. So there's not a lot of information as far as towers come. They don't happen. I mean, as far as monopoles and like flagpoles, they don't fall that way. It's not a weak point, it's just designed that way, but it's designed about 2/3 of the way up to where it comes down just like that. So there's no, that's the reason that most all of your ordinances all over the state of Tennessee and Virginia and North Carolina and Georgia that we work with, they're designed to where like 75% of the height of the tower is the setbacks that we require. And your ordinance requires the same thing. That's the reason it's set that way. So that's a normal.
Eddie?
What I was talking about is she makes an argument that a variance could be granted for the tower in accordance with section 11.6 F, F 1, 2, 3, 4, and 5. But this is still a special exception request and not a variance request. And the confusion is, and a lot of times it gets worded this way even among ourselves, our cell tower section 7.4 gives the board the authority to reduce separation distances if the goals of the zoning resolution would better be served thereby. It's not an additional variance request. It's still part of the special exception request. So they're not requesting a variance. They're requesting a special exception, but they're appealing to the board for relief based on section 7.4 D5, or no, D7 is what they're requesting. Well, actually D6 and 7, because this one doesn't meet the separation or the setback requirements.
I believe this one meets the separation requirements.
Separation from other antennas. I'm talking about the separation from property lines with a residence on it.
I thought the measure was from the residence.
It's from the residence property line. tower separations shall be measured from the base of the tower to the lot line of the off-site uses.
While she's looking at that, can you clarify something? The setbacks, are we discussing, or we need to wait that way?
Well, I mean,
Let's wait until we get the opposition up to, okay? Anything else, Roger?
that's all. I just wanted to clarify that difference between this being part of the special exception request versus a variance request.
Okay, thank you. Anyone here in opposition of this? We have 3 individuals, please, sir. Now it's time. Yeah. Got the right one.
Can I submit our package?
Please, yes.
My name is Sam Horton, and I was there at the April 2nd meeting, and I made a presentation to you folks. Primarily what I really focused on was section 7.4. The first paragraph of 7.4, there's 8 items that actually talk about your goals, about encouraging this and minimizing that and avoiding this, and we talked about, I addressed each one of them with the exception of item 6, which talked about cell tower configuration. And that really doesn't matter to me about that, so I won't belabor you with that. What I really want to talk to you about is the setback requirements and the separation criteria. The setback requirements, section 7.4(6)(a), it states that towers must be set back from an adjoining lot line a distance of at least 75% of the cell tower height. Over a year ago, that requirement was 300% of the cell tower height. If you got a 150-foot tower at 300%, there's a 450-foot distance in the lot lines. But that requirement was reduced from 300% to 75%, 225% reduction, which means now that the figure is 112.5 feet distance from an adjoining lot line. I submit to you that the backside of this property only is 36 feet, which means that it is 74 feet short of the requirement. Not 1 foot, not 2 foot, not 10 feet, over 74 feet short. As far as the separation requirement, section 7.4(a), and I can't call this to memory, so I'll just read it to you. It says the tower separation distance shall be 85 feet plus 1 foot for every 1 foot greater than 75 feet in tower height in relation to an existing residential use. Well, if you sit down and did the math, that's 160 feet. The nearest resident's property line is 66 feet, which means that there's a 94-foot bust. 94 feet short, even after the requirements were reduced from 300% of the height of the cell tower to 75%. Article 10, Enforcement and Administration, particularly section 10.1G states in part, a building permit shall be denied when required setbacks would not be met or when any other type of violation of the provisions and regulations of this resolution would result. Also, since this is considered to be a special exception under section 11.5, specifically subsection G, it states in part that the board may deny application for special exception if it finds and concludes that one or more of the following conditions holds or will hold. Particularly item 3, which says establishment of the special exception will not be in conformity with the purpose, intents, and goals of this resolution. Gentlemen, I submit to you, based on the setback and separation criteria, there is non-conforming. And it is not 1 foot, it's not 2 foot, it's not 20 feet. We're talking 74 feet, we're talking 94 feet. Simply, there's just no valid justification nor factual basis putting a cell tower here. The in situ site is too small and not conducive to accommodate a cell tower, and this is akin of trying to put an elephant on a postage stamp. I'm asking you to do not compromise your resolution requirements, your recommendations, and your goals on something that is so flagrantly flawed. They are way out of bounds. The site is way too small to accommodate this. So I'm just asking you to implement your regulations and requirements in your own resolution document.
Anyone else here in opposition? Please come forward.
I'm S.M. Johnson Atchley. I own property in William Brook subdivision. I received 2 notices from branches, but I own 4 homes there. All of them are rental homes. They're rented to professional people. This is an eyesore. Besides it not meeting the requirements, the site is far too small for a tower to be there, but I wouldn't want to live that close to a tower in my subdivision, and I don't want to ask that residents who rent from me to do the same. I've been a real estate broker for 37 years. I know what that does to property values, and it hurts the property values of more than 100 homeowners who are in the William Brook subdivision. So I ask you to reject this request for special variance. Thank you.
Anyone else in opposition, please come forward.
Good evening. My name's John Crabtree. I live at 2303 Big Springs Road. I'm the property that actually is within 60 plus feet of the proposed tower. I came to the April 2nd session, and during the April session, I said that I was, in my estimate, around 120 or so feet. My home, not just my property line, but my home was with 120 feet. I did a satellite measurement from GPS, and I'm about 155 feet from where this proposed tower is. I believe, according to their records, they said it was over 250 feet. I'm just quoting what I believe they said at the end of the meeting. So we're closer to that tower than what we're comfortable. I believe that we have these setbacks and these resolutions to protect the property owners who don't want something right on top of their property that is something they're not comfortable with. That was my assumption. So as the property owner who is actually adjoining this and going to have the tower right there in their yard, almost literally, I would like for you to consider that you are here to protect us. You're here to help us as well. And you're here because we wanted our voices to be heard. We did reduce the setback limits, but we've already reduced the setback limits to help out the cell phone towers. And now are we going to continue? I know we were on hold basically to get some information from the zoning board itself, not just the Board of Appeals. I'm not sure, I didn't go to any meeting for that, but if that hasn't happened, I would request that as well, just to get an overall view instead of allowing them to come in. And it should be around 150 feet from my property line. It's 60 and change. So I'd like for that to be considered, please. Thank you, Jim.
Anyone else in opposition? Discussion, board?
Yes. I'd like to clarify. If you look on the bottom of page 1, setback should be 112.5 feet, and the site plan reflects 66 in this document. I'm asking to clarify what the setback should be and what the setback they're requesting.
The setback should be 160 feet.
That's the separation.
Well, the separation, yes. The separation, are you talking about from the property line to the residential use?
I'm asking what the regulation says it should be and what we're being asked to approve.
The setback from the property line behind the structure should be 75% of the tower height.
So that's the 112.
Correct.
So 112 is the regulation, the new regulation.
Correct.
And the actual that they're requesting is
32?
32 feet.
32 on the side of the railroad.
32 abutting that property line. Now, but the separation distance applies to the property owner next door. So that should be the 160.
We got four sides of this thing.
Correct.
One's the road, one's the railroad, and you got property.
Well, you've got three sides, it's a triangle.
Yeah.
You've got,
Unless
from
they
the
all
road,
go back and forth.
from the road right of way to the railroad tracks right of way should be the 112.
All right, and it is.
No, it doesn't mean any of
It
it.
was, to Big Springs Road, it is 88.05.
88 feet. And it should be 112 also?
Mhm.
So, from the tower to the road, it should be 112, and they're asking for 88. Now, you face the place, and on the right, Mr. Crabtree, is that right?
I'm sorry?
Yes, Mr. Crabtree's the gentleman that just
You
spoke.
face it, he's on the right.
Correct.
Yes.
And that setback should be 112?
160.
160. And it's
So up here it's
66.
160, and it is
66.
66. And from there to the railroad, it should be 112.
Correct.
And it's
It is.
32.
32.
And on the left-hand side, you're saying it goes down to the little
Well, it's,
overpass.
It's well in excess of the 112 and 160 all the way.
So we miss it on three sides.
It misses on three sides.
Okay.
Okay, and I can show you, if you want, on one of the plats we gave you where we measured those. Okay.
I know what Stan's going to ask me. I did take your request before the planning commission, and they had no interest in revisiting the reducing the setback or separation distances.
May I address just a couple of
Yes,
issues
ma'am.
that he's raised? As y'all know, I'm Mary Miller. I'm here on behalf of Branch Communications and T-Mobile. I live at 3918 Shipwatch Lane in Knoxville. Two things I would like to point out here is we have provided radio frequency maps and a certification from our radio frequency engineer that shows that we have a gap in coverage. We have a significant gap in coverage in this area. That's what this tower is being built to provide. We cannot find another site in this area that meets the setbacks to provide the coverage. The affidavit of Mr. Sullivan not only says we can't co-locate, but I want to clarify, it also says we can't find another site where we can meet the setbacks. We've looked at one other site at Rubbermaid. It cannot meet the setbacks. It cannot meet the separation distances from the other towers either. And we've tried to go to some of the big parcel owners. So in other words, we've gone far and beyond to try to find, and we've not been able to find one. Okay. The other thing I would like to note, and we talked about this, we have submitted a fall zone letter, which certified by the engineers who build this tower, that say that it will fall within itself, and that the fall zone is less than 66 feet. So, the one thing I would say to the board is we talked today about the possibility of trying to lower the tower to 130 feet. We could do that, and we would propose that as an alternative solution. The problem with lowering it to 130 feet is that then you remove probably one or two co-location opportunities. At this point, it's built for at least 2, if not 3 additional co-locators. But what happens is it gets that low, then you're gonna have somebody coming in another year or so looking for another site in this area.
But even that doesn't meet the setbacks, does it?
It still wouldn't meet, you're right. Would be
Clarify
closer.
one thing for me on this. You said you have a shortfall of coverage, correct?
Right,
You have, in other words, Branch Communication has the shortfall.
fall of coverage.
Okay.
And there's a Sixth Circuit case that says if there is one carrier that has a shortfall of coverage, we're obligated to allow them to build a tower to provide coverage.
Who says we're obligated to do that?
The federal government.
For any carrier,
Yeah. The federal government has sold these
Okay,
bands.
and how many carriers do we have right now?
Mr. Perry can address that better than I can.
carriers in the area, there's 13 authorized by the FCC, so you could have 8 more coming here.
Okay, so we got 13 towers going to be sitting there side by side, possibly.
Well, I hope not. That's the whole point of these, is to try to have people co-locate on them. And that's the problem. It's a catch-22. If I build it taller, it's harder to meet the setbacks, but you're gonna have somebody else coming in. I may be representing them, Mr. Seymour may be representing them, but somebody else is probably gonna be coming in at some point to ask for another tower.
Why don't you put yours on somebody else's tower?
But we've tried that, and our RF engineers can address it. The next closest tower is too low, and we're still gonna have that gap in coverage.
Too low in height?
Yes, because what's happened is it's already got 3 antennas on it. The next closest one, I believe, is the one at McNutt Oil on 321, and it's already got 3 antennas on it.
Okay, maybe I don't need to talk about this until we decide on this, but this jumps back into Mr. Perry's deal. Technology. What technology's out there that would make it not necessary to have a tower? We're sitting here, we're just taking what you guys tell us. We don't know, but we got a consultant. Do you know?
The question is, other than cellular communications, is there anything else out there we see on the horizon that's going to take care of the the towers that we're using, such as satellite? No, satellite's not. There's a natural thing in satellite that won't work because you can't get enough power in space to be able to transmit and penetrate any kind of place on Earth, and so that's out of the question. In a rural area like we have here in the Maryville area, there's nothing on the horizon right now that will replace the cellular communications data transmission. They're around the University area of Tennessee, in Los Angeles, in Nashville, Washington, and New York. They're doing an experiment whereby they put small, we call them DASs, distributive antenna systems. They're small antennas on telephone poles every 800 feet, and their range is only 200 yards. It's not cellular. It's kind of like an extension of Wi-Fi. It's like putting a big antenna on a 35-foot pole out here from Starbucks, from their little Wi-Fi. It works the same way. That's a very, very expensive situation. It hasn't been proven yet, and the reason that they're looking at it in Knoxville, because around the university here, it's really highly concentrated. You got a lot of people. You got 32,000 people there within a mile of everything. So here, where we got everybody spread out, there's nothing on the horizon technology-wise that will replace cell towers. Now, remember when we first started cellular back in 1973, actually 1980, the towers were real tall. We had 300-400-foot towers. And as they've come down, they keep getting shorter and shorter and shorter because the coverage of each one of the cells is getting smaller. Now, the problem we have now is that the more data, your television, your streaming, the voice is very small, texting, all that sort of thing, it forces the transmitters on the towers to be at full capacity. When they're at full capacity, your service range is pulled in. And that's what they're running into. All the carriers are, not just T-Mobile, but all the carriers are. So as a result, if you want the smartphones, and you want all the good stuff that's on it, and all the apps that's on it, you're going to have a lot of towers. And what we're trying to do here in Blount County is to keep it from being like a porcupine. We don't want 3 towers right side by side. That's why we have a restriction on them. They can be more than 1,500 feet apart. And even that's getting to be kind of tough. That's what they're running into now. Because the range of each tower that they have is about a little less than 3/4 of a mile. I mean, that's depending on the frequency, depending on which one of the kind of carriers it is. For example, Verizon and U.S. Cellular are called cellular carriers, and they operate at a very low frequency. Think of it as an AM radio station, okay? AM radio station you can hear all over the country at night, for example. If you look at AT&T, T-Mobile, Cricket, and the other carriers, they're called PCS carriers, and they're way up, kind of like an FM station. FM stations, the same power can only be heard in a very small area. So, and that's what they're running into. And the problem with the lower, I can't get everybody get on the lower frequencies like Verizon and U.S. Cellular. There's only so much bandwidth available for that by the FCC. And so as a result, they've had to shift everything up. And when the higher your frequency, the shorter your range, and that's what we're running into.
Are you familiar with OnStar?
I am.
Is it off of satellite?
It's off satellite.
And you're saying, well, they can keep up with my car.
They can. That's one car. That's not 320 million cell phones. That's the problem. And it's just a burst. I mean, from your car, when you talk to the satellite, it only takes up a couple millionths of a second. If you had 320 million cell phones like we have here in this country, I mean, that satellite, you can't switch that many up there. There's not enough power in space to be able to do that. I mean, you're talking about a horrendous, a major obstacle that nature won't let you overdo.
Okay. You made a comment that we don't want the landscape to look like a porcupine.
Correct.
Okay. And we got zoning to try to protect it to not look like a porcupine.
Correct.
Okay. If you've got zoning that prevents you from having a porcupine effect to where you'd have coverage, what's the answer to where you will have coverage?
That's a good question. The question is, okay, if we don't have coverage and we've got our setbacks are too stringent, for example, to allow them to put up a tower somewhere, and again, I don't have any dogs in this hunt at all that you guys are listening to today, but in that situation, if you get into court, if you turn down the applicant, and you got to make a decision tonight. You can't put it off again because you're only allowed 60 days from the date it was applied for. This is our 60th day, so we got to make a decision tonight. Now, if you say, okay, no, we're not going to, we're going to deny it because your setbacks are too close. You don't meet the setback. You don't meet our requirements. Okay, and then if the carrier goes to court and says, well, we've been discriminated against because we can't provide service that we're required to by the federal government. Federal court, what are we supposed to do? And the odds are that we'll lose. We've lost here in this same situation before up in Townsend, remember that. So it's just a matter of, okay, are we going to enforce our rules and test them in federal court, or are we going to try to work something out between the neighbors and the cell towers people? I mean, that's just where we are. Now, the one good thing about this particular applicant, again, I don't have any dogs in this hunt, is that this is not a carrier that's an applicant. It's a independent company, which is what you want. Because you've got one of the 5 carriers we've got in this market will not let anybody else on their tower because under the old rules. And that creates a major problem. And so in a lot of places you'll see here in town, we've got 2 towers right side by side, which is stupid. And that's what we've stopped. And when Roger put the new rules together and the Planning Commission put these together several years ago, that's what we stopped by having 1,500-foot separation on them. So as a practical matter, I mean, it's up to you guys what you want to do, but you have to make some kind of decision tonight, pro or con.
I understand if we deny someone who meets all the requirements being sued. I don't understand denying someone that doesn't meet any of the setbacks and them suing us and winning.
Okay, and the reason being because what the testimony was that there was no other alternative sites that are in the area, but they're required to provide a certain percentage coverage of the market by the federal regulations. And the federal regulations can again, this is the judge in the federal court can say, well, wait a minute now. They have to have the coverage by the FCC requirements and under the Communication Act of 1996. And the county here has got, they're too restrictive on their setbacks. It's got to be, that's a judge's call. And the municipalities have not had a good track record in federal court on those issues. They've lost almost every time.
That scenario says we shouldn't even have setbacks.
So,
What a lot of counties have done, as a matter of fact, Wilson County just did it. I thought it was kind of a neat trick. What they did was they said, okay, any tower that's under 200 feet can be an administrative permit. Doesn't have to go to the Board of the Planning Commission or the Board of Zoning Appeals. So instead of you guys having to take the heat, Roger would have to take the heat.
So in essence, what my federal government is telling me is that in a free market system, I have to guarantee someone to make a profit.
No, it's not what they're saying. They're saying that they got to provide a service. Doesn't necessarily make a profit.
But the people are already getting the service.
But then if you deny one, then you're discriminating against them.
Well, if they don't meet the standard, if I have a standard of 70% and a student comes to me and they have a 69.9999999 on that exam, and they say, well, make an exemption for me. Well, what is my criteria? It's 70%. Then why should I go down to their criteria when I keep my standard? Then why do we have a standard? That's my question. Why do we have a standard then?
Well, as a practical matter, from an instructor standpoint, from a teacher standpoint, and I teach at the
I'm
university
talking
too.
about
Yeah.
anything in
I
life.
know, but I'm talking about, yeah. In that particular situation, you don't have a mandate from Uncle Sam to say, give that kid a 70%. Here, this is based on merit. And in the cellular world and the communication world, the merit's not part of the issue. You're comparing apples and oranges.
So rules, and I'm not addressing you, but
then
rules and regulations only apply for certain individual organizations, not for everyone.
No, that's not true. They apply for everybody. Here's the issue that you're looking at. Number one, you have an applicant that does not meet your setback or variance your requirements for setbacks. Okay. Number two, the opposite of that is the federal courts have ruled against municipalities that have issued a denial order. It's got to be in writing, incidentally. Denial order based upon that when there's got to be a service coverage in this area and there are no other places within a 1,500 foot or whatever the requirement is. In this case, it's 1,500 feet of the proposed site. So, it's just a chance if you want to take a chance. And I don't know whether they bring a suit or not. That's not my business, but I'm just telling you, you have an option.
For this, we'd be setting a precedent to approve every cell phone tower request that comes in.
That's why we revisited the setback and separation requirements last year, because it was becoming very frequent that we had to, and we did have very stringent requirements. But now I can't say that they're more stringent than, I can think Alcoa is probably a little more flexible than we are, but everybody else we're right in line with.
We've just reduced them. This doesn't mean any of them.
Well, I think it's not that it doesn't mean anything. It does mean something. It just means it hasn't been tested.
Anybody else want to make any comments? Yes, please. My battery's running out of power.
John Crabtree again. I have what's called a hotspot. We're asking how can you get cell phone service without additional towers? Where my mom lives in Rome County, if I stand out on the middle of a hill, stand on one leg and hold the cell phone up as high as I can, I might get service. So I plug in a mobile hotspot and I've got service everywhere on her property. So there are options as far as getting to coverage, mobile hotspots. But a concern is, I think last week we said that there's 18 carriers, 13 carriers, and we've got 8 here. That's 5 more carriers. They're saying that we may be discriminating against this T-Mobile or Branch Communications if we don't bend our setbacks and everything to what they need. The dangers to me of that is once you set the standard of 30 feet, 60 feet, 30 feet or whatever it is the other direction, and you don't meet 3 out of 4 sides, the first person that you say no to says, you let T-Mobile do it, now you're discriminating against me. But as long as we have our standards and we meet our standards, which have tightened, I feel like we would be at less risk. Last week we said that each carrier has a certain amount of percentage of property within Blount County that they have to cover. Is this half mile going to determine whether T-Mobile meets that coverage of Blount County or not? I don't think we ever got to that. We were just saying that you have to cover a certain percentage of the land, not people, of the land. Is that correct? Percentage of population. Okay, I thought it was land area. It's basically the same. So is this half mile, 200 people, going to determine whether they meet what the federal guidelines have said or not? I don't believe they answered that question last week or last month. But I think those are some key things to think of. They're not meeting on 3 sides by a large percentage. So once we go down to 30 feet, they might as well put it on the property line, because if we deny the next person, well, you went from 112 to 30, why can't you go from 30 to 5? So that's all I was wanting to add to that. Thank you.
Thank you. Yes, ma'am.
Again, I'm S.M. Johnson Ashley, and by the way, I live on LeConte Drive in Maryville. I agree so much with what he said. There are guidelines, and you're making an exception to the guidelines if you approve this tower, and then towers can be put up everywhere in far smaller space than what you have regulations for. I understand to some degree about their right to be able to have a tower. I also believe just as strongly, if not more so, in the right of all the homeowners around there to not be infringed upon. Thank you.
Anyone else?
You know, I think if I owned a communications company, the first thing that I would do before I even tried to get all the drawings and try to build a cell tower is I would look at the local laws and study them and make sure that the site that I'm about to build a cell tower is going to be compatible. The communications company apparently didn't do that. And this doesn't only have to be the place. If they say that they can't find any other places, there are a lot of places that they could put their cell tower. If you ever saw this site, it's down in a valley anyway, and it is around a lot of people, highly densely people-populated area, over 300 homes within approximately 2,000 feet. You've got two daycare centers. You've got William Blount, or Miss Blount Elementary School. You've got a high school and a junior high that's probably within 2,000 square feet. So you've got a people-populated density area here. So I don't think there was enough forethought. And when they went and got all of this stuff together, and they said, well, maybe we can just shove it through. And if you looked at what your requirements are, it's like I said, it's not 1, 2, or 20 feet. I mean, it is outlandishly out of violation.
Any other comments from either for or against? Yes, ma'am.
I'll try to be quick because I know we've taken a lot of your time. A couple of things that we would like to address is we're not asking you just to waive the setbacks. We're saying we've established we can't find another site in this area that meets the setbacks that will allow us to provide coverage. I'd like for Jamil to get up and just say, so we have testimony on the record, there is a significant gap in coverage here. And if that's possible,
Absolutely. Jamil Suarez, T-Mobile RF engineer.
Your name again?
Jamil Suarez.
Spell it.
S-U-A-R-E-Z. Last name. First name Y-A-M-I-L. So what we have here, it is a definite coverage gap in our network. And this is why we're before you. Just like everyone, we have a a commitment to our customers as well. Just like AT&T, Sprint, and everyone has commitment to the paying customers, we also have that. And so we have a number of complaints in the area, and we have a huge gap as far as the coverage, and what we're here is to try to remedy that. So.
And you would say there's a significant gap in coverage?
Yes, there's over a mile, particularly on the road just north of here.
How much under 70% is it? Do we know?
I'm sorry, second?
How much under 70% required for the shortfall coverage is it? I mean, is it 60%?
I don't have a exact percentage, if you will, but I do know that it's up there as far as, in our customer database and our complaints, obviously do show that there is a big coverage, but I would say probably very close to the 7%.
So
Right.
FCC tells us we're supposed to give 70. You're supposed to have 70% coverage, correct? So how much of that delta 70 do you cover?
I don't have a number for you as far as a percentage, but that's what we're trying to do. We're trying to build up for us to comply, if you will, with the FCC and that regulation.
Okay.
The other thing I would just point out is we are only asking you to waive these requirements because we cannot find a site in this area that will meet the zoning ordinance requirements. I would not come in here I hope not anyway, every time and say, please waive the requirements. Part of what we've tried to establish with Mr. Sullivan's affidavit and Mr. Suarez's testimony is we can't find another site in the area that would meet the zoning ordinance requirements, and that is the only reason we're asking for a waiver.
Absolutely.
Okay, thank you. Any other discussions? Yes, sir?
I promise this is the last time, so I don't waste your time. They said last week that it was 70%, but they didn't bring back their numbers. They say that there's a number of people that have complained. I'm just wondering what that number might be, because 2 is a number. So you asked how many people have complained. They said a number. How close are you to the 70%? We're trying to get there. So I think that that's relative information if we're going to, especially if we're going to talk about removing some of the policies that we have, some of the setback rules and regulations that we carry. That's all. I promise I won't be back. Thanks.
Okay. Discussion, board?
Did the county commission just not want to address it at all?
Not the county commission, the planning commission.
Planning commission.
Yeah, they had no interest in reducing them any further.
And if you went past the planning commission, you go to the county commission, right? Or is the planning commission the final say?
In matters of this and yes, generally speaking, changes to the zoning regulations get recommended from the county commission or planning commission to the county commission.
My recollection was that last time we just asked you to go back to the planning commission based on what Mr. Perry told us and said there's a whole lot more coming. I'm not sure we were asking them to reduce what they had already reduced. It was just to make them aware based on the information that he gave us. They get ready, here it comes.
Well, I took that as a, being the first one with our new setback regulations, what I was hearing was there any interest in changing those?
Any other discussion with the board? Do I hear a motion?
Motion to
Do I hear a second?
I second, based on the fact that it doesn't meet the setbacks and that we have asked for any additional input from the planning commission, and there seems to be no no willingness to change the setbacks.
I just make a comment on my motion. I don't know how in the world we could take this much variance and approve this, and then look at any other request that would ever come in here and deny. You know, if they were asking for a foot or two, I could see that we might work with it. But with this variance, we might as well tell the planning commission to take what they've set up. Go fly kite.
Let me get this clear. Larry, do you want to put the, based on the setback requirements not being met and?
Yes.
Okay, as part of your motion?
We had a motion that's been seconded. We're ready to vote? So a vote yes means to
Deny.
deny. Okay. Got
Bruce-
that, guys? All right.
Bruce Damrow,
Yes.
Larry Chesney, Stan Hedrick,
Yes.
Brian King.
Yes.
Motion to deny passes.
Okay.
Is that it?
No. Oh, no, we got more. But wait, there's more. What's the next one here, Roger? I'm kind of out of sync
Well,
here.
hold on, I'm gonna have to get another sheet.
Special exempt. Yeah, we have Gary Jarvis Drive, special exemption.
Yes.
Okay.
This is a request for a family commercial enterprise to be located at 129 Gary Jarvis Drive. The special exception request is for an automobile repair shop. The property is identified on tax map 101, parcel 6.04, and is zoned R1. The requested use is one that can be approved as a family commercial enterprise through the special exception process. The applicant has already been operating the business and was issued a stop work use order in January. The applicant did respond and needed time to get a site plan put together and now has made his application. The site plan does show a 30 by 36 garage that houses the requested use. The structure meets our minimum setback requirement for residential accessory building of 10 feet, but does not meet the 20 feet required for commercially used structure. This accessory building was in existence prior to this request. It was used residentially prior to this use. The site plan shows an addition on the back of this structure that is claimed to be used for residential purposes only, and that's a new addition. No buffer is indicated on the site plan, but would be required if this use is approved. The buffer should screen this use from all abutting residential use properties. I've highlighted items in section 7.10 below that I have a few concerns with. First is that the structure houses the use is 1,080 square feet, which is a little over the required 1,000 square feet. Another concern is in section 7.10F can be achieved with close proximity to other residential uses. Hold on, but an appropriate buffer may help achieve this. I was thinking about noises at that point. Lastly is my concern in section 7.10A, specifically, there shall be no storage of materials or equipment outside of the principal dwelling or accessory building. Currently, the applicant has several automobiles parked outside of the garage, and this is what caused the original complaint. And to clear up the 7.10F is, it mentions in there that the activity should not create glare, fume, noise, anything detectable to normal senses on abutting residential used property. That could be a problem with the nature of the automobile repair shop, but that's why I said a properly installed buffer may reduce that risk.
Is there anyone here in favor of this? Please, sir.
James Baker. I'm the owner of the property. I'm in favor of it.
Okay, any comments that you'd like to make?
Well, we built on that property, that garage, and that's all it was ever supposed to be, is a place for Dad and his kids to work on their trucks and their hobbies and stuff like that. Due to life changes, I went through a divorce, and I have full custody of one of my children. I made the decision to quit my job and come home and try and play by the rules and do whatever I had to do to survive for my family. Never intending to try and be a bad neighbor. There's some of my neighbors here today. Never had any bad intentions to, upset anybody with noise or a vehicle being parked someplace or something like that. We all have a common road. We live on a private drive. There's 5 houses on that road. All of them face the same way. So there's a road that runs right in front of everybody's house that we own that property of, which means for my neighbors to get to their house, they have to go through my property. There's been a few incidences on that piece of road where a fella might have been bringing a truck on the back of a trailer, had some type of problem with the truck or the trailer or the unload procedure or something. And it's inconvenience to my neighbors to get a right-of-way, to get to church, wherever they needed to go that day. And it seems like whenever something like that happens, it's always when somebody's needing to go down the road. So I have inconvenienced my neighbors. I'll admit to that. I'm not intentionally. But I have inconvenienced them. I have also apologized. And I've also tried to do things to be a good neighbor, not to be a bad neighbor. Tonight, listening to all you guys and cell phone tower people and stuff like that, it seems like everybody's pretty cut and dry on whether you meet the criteria of what's going on around you. And just by some weird chance, I do meet that criteria. I never knew nothing about any of this stuff until it's kind of getting thrown in my lap. So I'm learning as we go. The business that I have at home, and it is to work on trucks, primarily transmissions. It wasn't supposed to be like that 5 years ago. 5 years ago, we wouldn't have even been standing here today. But because of the way the world changes for everybody, I'm having to get a crash course on how all this works. I want to be a good neighbor. I want to be a good, productive member of this society. I want to provide for my family. Anything I could do, I mean, if it's just plant a row of trees so they can't hear some noise, I want to do that. I don't really know what to say or what to do. I know, when it rains for 3 months straight in a small town, and your whole yard and your whole property is pretty much the consistency of pumpkin pie, and a truck drives across it. It leaves some pretty bad marks. I've been a victim to that on my property. And my neighbors have shared the same mess, so to speak. Like I said, I do fall within the guidelines of the family commercial enterprise. My building is 30 by 36 feet on the outside. Now, I don't know how they measure square footage. If it was on the inside, it might be a little less. So I'm still within the boundaries of I guess, the law, county law, or whatever it is. And I'm willing to make any changes to help out. Like I said, I don't want to be a bad neighbor. I've been forced into a situation that I've tried to make the best of. And I've even told Roger, if you guys shut me down out there, you very well may be doing me and my family a favor. But I don't know. Today, that's all I got. So I'm in favor of it.
All right.
For sure.
All right. Thank you, sir. Any questions? Okay. Anyone in opposition of this here?
My name is Terry Wells. My name is Jamie Griffin. She's going to give you some materials in a little while. My house is located at the end of that street. And so obviously, as Jamie has said, basically I have to pass his house in order to get to my home. There are some problems with this to me. First of all, there's what is called a restrictive covenant that has been placed on all of Springview Estates. This includes 3 streets, including Gary Jarvis Drive. At the time of purchase, this was connected to the deed, and so each homeowner would have signed these restrictive covenants saying, this is what I will do, this is what I will not do. Number 7 within that restrictive covenant says no commercial activities of any kind shall be permitted. Number 9 says each resident shall have sufficient space to park 4 passenger cars off the street. You've already heard about that. Number 10, all lots are to be kept in a neat and clean condition at all times. No accumulation of trash, debris, or junk cars shall be permitted. At this time, there are at least 2 cars that are not used by Jamie as regular transportation. I consider them junk. That deals basically with the covenants of Springview Estates. I'd like to also draw your attention to the zoning laws of Blount County. Section 7, Article 10 of the Family Commercial Enterprises. It says no storage of materials or equipment outside. You've heard about this. Number 2, or letter F, there's not to be any noise or anything or any odors that I can smell. The other day, he was trying to start a diesel truck. There was a billow of smoke came out of his garage. I was in my garage. Granted, my garage door was open, but that smoke came into my garage. At times, we have a screened-in porch on the back. The smoke has come into there. So it has come onto my property. The other problem I have is really, as it's been said, this is a private road with easement for each property. The majority of this traffic, of the traffic on this road is people coming in and out of his business. So there's extra wear and tear on this road, of which the homeowners on that road are responsible. There's not an area large enough for a rollback to unload a vehicle. So therefore, it is forced to either back out to Murphy Road or to figure out some way to turn around. As he said, there was one day a wrecker that broke down and was there for a whole afternoon blocking the entrance of my driveway. The other problem I have is if I would decide to sell my property, this also creates a problem. I realize the assessed value of my property would not change, but I have talked to a couple of realtors. One of them put it this way. They said if you had 10 people that would come and look at your property, would 10 people want to live in that business, with that business next to the house that they have just purchased? And so therefore, I think my property value would go down. For instance, on the other side of this business, there is a house that is presently for sale. In the last month, that house has been reduced by $2,400. I cannot say why it's been reduced, but I'm assuming that it might be because there are certain people that are looking at that property and don't want to buy it because they're living next door to there. Lastly, the business could end up doing serious damage to my house. One day there was a rollback that did not have a place to turn around. It had a dual-wheel pickup truck on the back. He came onto my property, which is concrete, and he backed toward my house, stopped within 6 inches of hitting my house. I went over to Jamie's and asked him about it, and he plainly told me I have no control over the rollbacks or the wreckers that come on and deliver vehicles to his place of business. It seems to me, and I realize the hardships that he has endured, but I just feel that this is a very bad place in the type of development that this is, to have this kind of business.
Is there anyone else in opposition?
These are some pictures that will, and on the back is an explanation of what the picture shows.
Would you like to enter those into for us
Yes,
to? Okay. All right.
Also, I have a copy of the restricted covenant for Springview Estates. Would you like a copy?
Yes, please. Any discussion of the board?
It's my understanding, based on this conversation, that this does not meet the criteria of the Springview Estates, nor does it meet Blount County criteria for business in that area that's zoned the way it is.
I can speak for the county regs, and the three concerns I mentioned in the memo are the shortfalls that I see. The shortcomings that I see as far as the regulations, that normally on a special exception we require a 20-foot side setback. This structure has a 10-foot side setback. Historically, if a use is going into an existing structure, we've granted some leeway on those. But that would be a consideration. The 80 square feet over the 1,000 square feet, as far as what an accessory structure could be size-wise, if the business is conducted in it.
But Roger,
And then
this is zoning, irregardless of the subdivision. Is this area that's zoned the way it is from the county's point of view, does it permit a commercial activity?
Yes.
It does.
It's R1, and if you look under the R1 requirements, it says things that can be approved as a special exception, and it mentions family commercial enterprises. If you flip to family commercial enterprises, you'll see it gives you a list of uses that can be approved, and automobile repair is one of those uses.
One of those requirements is too, all things have to be stored inside.
Yes, that's.
One of the pictures that I presented to you shows a lawn service truck that is sitting in front of that garage. If you look at it closely, the box of that truck is higher than the door of the garage. There's no way to put that thing inside. And this is not the only truck that size that has been in business.
That's a two-car garage, right? How many cars you work on at a time?
In the past, I mean, it's got pretty hectic around there, and people would brought cars, me not even knowing that they were coming. So in the past, I have had quite a few cars. As a matter of fact, when I first met Roger, he asked me, how many cars do you have on your property right now? And I was completely honest with him. Every car on my property, including the ones that I own, there was 10 cars. And he was like, how many of them can go away? And I was like, well, there's been like one or two of them that have been here for 2 years or better. Like I said, I'm willing to do whatever it takes to accommodate my neighbors. I don't want to be a bad neighbor, and I never have. And I can't believe that I've been over there working, and never once have I had a noise complaint. I've never had the police called on me over there saying that you're being too loud, that there's smoke coming in my garage, that I'm blocking the road. There's never been nothing happen over there. They've never walked over except for that one time with the wrecker, which, yeah, the wrecker about hit your darn house, man, and that would have been awful. But that's why we have homeowners insurance and stuff like that. I mean, if a wrecker came and hit my house, I would have to claim it under my homeowner's insurance. It wouldn't be go over there and talk to my neighbor because he just got his truck dropped off by a wrecker and now a wrecker hit my house. Some of this covenants and restrictions in my neighborhood, I'm not real familiar with. I'm not. There's not a committee in my neighborhood. There's never been one formed. And from what I've always heard, that, you know, if there is somebody like my neighbors here that are upset with something that's going on, then they need to find one other person in my community or in our neighborhood to form a neighborhood committee to stand up for the community.
Could you operate just with 2 cars being in the garage at any time? And that's the limit.
Well, and I've thought a lot about that since I've met Roger. I could do cars only in and not parked on the property and completely scheduled in. However, the problem I've run into, and I've been trying to practice some of that here recently to see how it will even work. The problem I've run into is people coming back and picking their vehicle up. So I got their vehicle done for them on time, and we got a plan for you to come get it. And then I call you up, hey, Mike Lewis, your truck's done. I got your transmission finished for you, buddy. Well, Jamie, I'm down here at the courthouse until 8 or 9 o'clock on Tuesdays. You know.
Well, I think the context of the whole thing is it a family enterprise? Sure, I'm totally with you on trying to do things to make a little money and all that. And I think that's what the family enterprise zone was set up for, is to accommodate that. But this goes beyond that. So I got a problem with it.
Is everyone, when they purchase the property, given a copy of the restrictions? Okay.
I talked to the original people that designed and what designed to lay the property out, and they told me they did. Everyone on, I can't, there's Barabo and there's John Bolden.
Okay.
Those three roads right there, this person told me that there are restrictions, which I gave you, given to everyone on those three streets. And they are connected to the deed. So if the house is sold and handled by a different realtor, they still should have received that copy.
Okay, thank you. Other discussion from the board? Do I hear a motion?
Well, as bad as I hate to limit somebody making money, at the same time, you got to consider the other things too. I have no problem if you're working on 2 cars at a time, if they're kept inside, but it doesn't sound like that's gonna be possible. So-
Well, I'd hate to sit here in front of you and lie to you. And I'd hate to sit in front of you and promise you I could do that. And then, you know, then there's 2 more cars waiting to come in and the other 2 ain't gone out yet, or some type of mix-up like that, and then I've sat here and lied to you. So
I understand that.
what Terry was talking about, 4 cars on the property. I mean, I can house at least 4 trucks in my 2 driveways.
It sounds like you got enough business, you need to be in a place where you can handle something bigger. But based on that, and you not being able to keep your stuff in the garage, I make a motion we deny.
Second.
We have a motion to deny and a second. Roger?
Hold on, let me get that section.
Yes means deny.
And who got the second, Larry? Stan Hedrick?
Yes.
Larry Chesney?
Yes.
Bruce Damrow?
Yes.
And Brian?
Yes.
Motion to deny was approved.
Okay, the next item we have,
So, sir, everybody, I'm sorry, I don't know what to call you all as a group, but
you're,
how do I, is there an appeal? I can do an appeal, on this decision?
You can, an appeal of my decision comes to this body, an appeal of a decision this body makes, you'd go through civil action. It actually go to court.
Well, say I could do them with just 2 in the garage at a time.
Well, I think if you could do that, then you gotta go back to Roger and re-enter it again.
Can I change one word you're using quite a bit? Excuse me. Don't say cars, say trucks, diesel trucks. And I just don't understand how you can stop that smell from coming over. I mean, I sympathize with Jamie's situation. That's one of the reasons I haven't voiced it. And I really speak perfectly honest. I was ignorant as to where to take this issue. I'm not the original complainant. But these are trucks. You know, pickup trucks. And smoke comes from them, and as the wind's blowing correctly, that whole smoke comes onto my property.
Well, I mean, I also own a diesel truck, and at one point I owned 3 diesel trucks. So, I mean, there's gonna be, you know, smoke comes from diesels. I mean,
sir, maybe what you want to do is why don't you guys 2 talk, but right now your request has been denied, okay?
thank you.
And thank you. And we had to move on. All right. The next one, if I haven't lost my track, is on 949 Cars Creek Road. Correct, Roger?
That is correct.
All right.
This is for a bed and breakfast. The property is identified on tax map 84, parcel 17. and has a split zoning of R1 and R2. The majority of the property, including where the house is located, is zoned R2. The requested use is permitted within both zones as a special exception. This is a 39-acre tract of land with a home being located pretty close to the middle of the property. The site plan does not show the property boundaries due to the size of the property, but it does reference the distance to the closest property boundaries. Based on the site plan and GIS image, all building setback requirements are met. The house is located within a densely forested area that is sufficiently buffered from the neighboring properties. The parking will be handled by 9 parking spaces, which is within the range for a bed and breakfast according to the parking standards from the American Planning Association. The existing septic system will be used at this location.
Is there anyone here for this? Forgot what I was going to say.
Yes, gentlemen, I'm Justin Strecker. I live at 949 Cars Creek Road, and I'm just thankful tonight I'm not building a bed and breakfast in a cell phone tower. So I've learned a lot, but we have a maximum of 5 rooms that we would be able to rent out in the home, and essentially that's what it would be, is a nightly rental for people that want to come and do that. We're also using that as a ministry tool, so it's going to be something that we're going to utilize for people that need to, pastors and other missionaries and people that need to have a place to come and be refreshed in the Smoky Mountains. So that's what God told us to do, so that's why we're here. And that's really it. So we fall within the guidelines, and we look forward to a favorable decision.
Thank you.
These are 5 rooms in your existing house?
Correct. It's an existing structure. Yes, and it would be refurbished.
Okay, thank you. Anyone else in favor? Anyone here opposed? Please.
We live further down.
What's your name, ma'am?
Renee Hyatt, and we live further down on Cars Creek Road, and saw the posted sign about the meeting tonight. So this is the first we heard about there being a bed and breakfast being proposed. So my question would be, are there regulations for a bed and breakfast, the number of nights that anyone's allowed to stay, or who monitors that? And
there's no specific regulations in our zoning as far as how they conduct their business. There might be some regulations as far as serving the food. I'm not sure, but the state does. If you have food service, I think they do inspections to make sure everything's sanitary. I'm not sure if there's a amount served that. I think it's just if it's served to the public.
because then I heard the word ministry, so that could have a different meaning as far as long-term than bed and breakfast, which seems to be a nightly type of thing. So is that a different designation, or that still falls under the designation of bed and breakfast?
Well, no, if it's still a bed and breakfast, but anything that's a religious place of worship is permitted outright in our zoning.
Okay.
If it was just a place of worship, then they wouldn't even have to come through this process.
Okay, that's good information. Thank you.
Sir, please.
My name's Paul Irwin. I live at 1109 Cars Creek Road. My question is, are there regulations regarding the increased traffic flow on a small rural road? In particular, that section of Cars Creek Road is very narrow and very curvy, and I don't know the number of people that would be added to that traffic flow. Are there regulations that come to bear? Yeah,
they're pretty much covered in what's allowable in the zones. Usually a bed and breakfast is a minimal impact. I mean, 5 rooms, you could assume they would be adding 5 more cars to the road. And when you look in those zones that they're in, it limits the uses that can be approved. But it does in both of those zones list this one as one that can be approved.
Okay, thank you.
Okay.
I have a question. What is it? Why did they come? Which I didn't meet all the criteria.
I can't hear you, Larry.
Why did they have to come to us? This thing, like it meets all the criteria.
Well, like on all the special exceptions, we get this question a lot. I can't approve it in the office. Only thing I can write a building permit for or a use permit for is for residential uses. Yeah, so I mean, anything that's a special exception has to come to the board. They're supposed to bring to you a site plan that meets our criteria, and that's what your call is to make sure that their request is copacetic with our regulations.
But this doesn't, this meets every criteria?
It is yes.
It meets everything?
Correct.
Do I hear a motion? Do I hear a second?
Second.
We have a second. Roger.
Was that second Mr. King?
Yes. Yes.
Stan Hedrick?
Yes.
Brian King?
Yes.
Larry Chesney?
Yes.
Bruce Stammer?
Yes.
I went out of order and I'm going to get yelled at when they do the minutes, so. Motion approved.
Motion to adjourn, second. We stand adjourned. Thank you.